We begin with the lead House manager, Chairman Adam Schiff. Mr. Chairman, thank you for joining us this morning. I want to start with the president's first official filing. The quotes from there: a categorical denial of each and every allegation, calling it the fruit of a lawless process and a dangerous attack on our elections. You've now had the chance to review it. What's your response?
Well, it's surprising in that it really doesn't offer much new beyond the failed arguments we heard in the House. The facts aren't seriously contested. The president withheld hundreds of millions of dollars of military aid to an ally at war with Russia, withheld a White House meeting that the president of Ukraine desperately sought to establish with his country and with his adversary, the support of the United States, in order to coerce Ukraine into helping him cheat in the next election. They really can't contest those facts. And the only thing really new about the president's defense is that they're now arguing, I think because they can't contest the facts, that the president cannot be impeached for abusing the power of his office.
That's what I wanted to get to, because that's the argument. Alan Dershowitz is coming up, and that's the argument he's going to make. He says, quote, abuse of power, even if proved, is not an impeachable offense.
Well, that's the argument I suppose you have to make if the facts are so dead set against you. If the president has admitted to the wrongdoing, his chief of staff has confessed to the wrongdoing, his European Union ambassador has confessed to the same quid pro quo, you have to rely on an argument that even if he abused his office in this horrendous way, that it's not impeachable. You had to go so far out of the mainstream to find someone to make that argument. You had to leave the realm of constitutional law scholars and go to criminal defense lawyers. Even Professor Turley, who testified on behalf of House Republicans, couldn't make that argument. In fact, in the House made exactly the opposite argument, that abuse of power is at the center of what the framers intended an impeachable offense to be. The logic of that absurdist position that's being now adopted by the president is he could give away the state of Alaska. He could withhold execution of sanctions on Russia for interfering in the last election to induce or coerce Russia to interfere in the next one. That would have appalled, the mere idea of this would have appalled the founders who were worried about exactly that kind of solicitation of foreign interference in an election for a personal benefit, the danger it poses to national security. That goes to the very heart of what the framers intended to be impeachable.
Let's talk about Lev Parnas. You released a great deal of information from him. Of course, he's the associate of Rudy Giuliani, now indicted, who testified this week, has given a lot of documents to your committee, testified in public, I should say, who didn't testify to Congress. But there's only one reference to him in your brief. How much will you be using him in your argument? Are you concerned that he won't be seen as a credible because he's under indictment?
Well, look, you know, it is the fact with many of the people surrounding the president that they end up indicted. These are the people that the president has chosen to work with. People like, you know, Michael Cohen, like Lev Parnas, like so many others, Paul Manafort. And these are people that do have information about the president's misconduct. But right now, George, we don't know what witnesses will be allowed, and even if we'll be allowed witnesses. We can't really make a determination on which witnesses we'll call in the absence of knowing whether the Senate will allow any at all. The threshold issue here, George, is will there be a fair trial? Will the senators allow the House to call witnesses, to introduce documents? That is the foundational issue on which everything else rests. And one thing that the public is overwhelmingly in support of, and that is a fair trial. Imagine that you're a juror, people watching your show from around the country. Imagine that you're a juror and the judge comes into the courtroom and says, look, I've been in consultation with the defendant. I'm working hand in hand with the defendant. And we've agreed that I'm not going to allow the prosecution to call any witnesses, and I'm not going to allow the prosecution to show you any documents. I will only allow the prosecution to read the cold transcripts from the grand jury. No juror has ever heard that kind of a thing from a judge because it would be absurd. It would be a mockery of a trial, not a trial. But that is what Senator McConnell to date is proposing. But that's not what the American people want, and I don't think it's true to the oath the senators have taken to be impartial administrators of justice.
You're going to have to convince at least 4 Republican senators to vote for those witnesses. One of the key ones, of course, is Susan Collins, and she's been quite critical of the House process, saying, you know, you should have done more to enforce your own subpoenas.
You know, I've seen those comments. I look forward to addressing them at the trial, because I think what Senator Collins and the other senators need to realize is we did try to get these witnesses in the House. We subpoenaed many of these witnesses, and because of the president's obstruction, they ignored those lawful subpoenas. If you argue that, well, the House needed to go through endless months or even years of litigation before bringing about an impeachment, you effectively nullify the impeachment clause. You allow the President of the United States, by delay, by playing rope-a-dope in the courts, to defeat the power of the impeachment clause. The framers gave the House the sole power of impeachment. It didn't say that was given to judges who, at their leisure, may or may not decide cases and allow the House to proceed. So that is not the structure that the framers intended. And I'll make one other point, George, which is, I think, a powerful one, and that is Donald Trump's Justice Department is in court saying the House cannot go to court to enforce its subpoenas. Well, they can't have it both ways, and neither should the senators accept it both ways. The reality is, because what the president is threatening to do is cheat in the next election, you cannot wait months and years to be able to remove that threat from office.
Senator McConnell still hasn't released his resolution laying out the rules and timetable for the trial, but we've learned that he's been considering a far more compressed schedule than the Clinton trial. Fewer days for arguments, a compressed timeline, no guarantee of new witnesses, as we've discussed. What will you be fighting for on Tuesday?
Well, and it's telling that none of us have seen this resolution, except, I suppose, the White House lawyers. We'll be fighting for a fair trial. As I mentioned before, that is really the foundation on which this all rests. If the Senate decides, if Senator McConnell prevails, and there are no witnesses, it will be the first impeachment trial in history that goes to conclusion without witnesses. Look, I can tell you the atmosphere in the Senate when I came with the other House managers and we read the articles was one befitting something that has only happened 3 times in the nation's history. And I intend during the trial to be respectful of the senators, to operate from the presumption that they do take their oath seriously, but also with the knowledge that Americans are watching, that they're going to demand a fair trial. And if the senators don't give the country a fair trial, one that's fair to the president, but also fair to the American people, the senators will be held accountable. So that's the approach I intend to take.
Finally, Congressman, you're also the chair of the House Intelligence Committee, and each year your committee holds a hearing on global security threats. Politico is reporting that the Intelligence Committee is resisting coming forward in a public hearing because they're afraid of angering President Trump. What's the latest on that? Are you going to have a public hearing?
Well, unfortunately, I think those reports are all too accurate. The intelligence community is reluctant to have an open hearing, something that we had done every year prior to the Trump administration, because they're worried about angering the president. Well, part of their job is to speak truth to power. And I worry that they're succumbing to the pressure of the administration. And I'll say something even more concerning to me, and that is the intelligence community is beginning to withhold documents for Congress on the issue of Ukraine. They appear to be succumbing to pressure from the administration. The NSA in particular is withholding what are potentially relevant documents to our oversight responsibilities on Ukraine, but also withholding documents potentially relevant that the senators might want to see during the trial. That is deeply concerning, and there are signs that the CIA may be on the same tragic course. We are counting on the intelligence community not only to speak truth to power, but to resist pressure from the administration to withhold information from Congress because the administration fears it may incriminate them.
Congressman Schiff, thanks for your time this morning.
Thank you.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.